So one of the important duties of the president, David, is that you get to choose who speaks at the Wednesday lunch. And I first met, I think, Judge Pryor during a discussion about the death penalty, in which we were trying to figure out from all points of view what the right thing to do would be. And I was so impressed with the quality of his intellect and the thoughtful way in which he approached everything. And I wasn't quite sure who he was at the time, so then I went back and saw, oh, he was Judge Wisdom's clerk. And that explained all kinds of things to me. Judge Wisdom, of course, not only loved the ALI, he was much beloved by the ALI, although I will tell you, Judge, a sort of a funny story. When I was president of the ABA, I encouraged the ABA to give the ABA medal to Judge Wisdom. And so my husband came with me to our annual meeting, and I'd never really met Judge Wisdom before, and neither had my husband, and over the course of the 2 days, we had an opportunity to spend an enormous amount of time with him. And I am told that we were sitting at different tables, that at the final dinner where we had him for dinner, a waiter asked Judge Wisdom what he wanted to have for dessert, and then asked Barry, my husband, what he wanted, and he said, I'll have what Judge Wisdom is having. So it was... Judge Pryor is, I think, as most people in this room knows, a federal circuit judge on the U.S. Court of Appeals for the 11th Circuit. He was appointed by George W. Bush. President Obama appointed Judge Pryor to serve for 4 years on the U.S. Sentencing Commission, which, for our guests, is an enormously important group that you heard a little bit about today. It's a 7-member bipartisan agency that establishes federal sentencing guidelines. Judge Pryor graduated magna cum laude from Tulane, the Order of the Coif, but sometimes those people are, just as you know, really good at taking exams, and later in life, when people see how their intellect is applied, that's when those honors really start to make sense to me. And Judge Pryor, among other things, has received a number of honorary degrees. What I appreciate so much about him is that he has continued to teach and lecture, which I think is an underappreciated value for the members of our judiciary. So it's my honor to invite to address us today Judge Pryor.
Good afternoon. Thank you for that kind introduction. It's always a moment when you have to remember Judge Wisdom, who instilled in all of his law clerks a love for the Institute and its work, and without whom, whose mentorship I don't think I would be here. I also want to dedicate my remarks in part today to Justice Scalia's memory, who had a lot to say about the topic I'm going to talk about, and had a lot of influence, and some might say created some of the problems that we now have to address. 30 years ago, last month, the newly formed United States Sentencing Commission circulated the first discussion draft of proposed sentencing guidelines. That draft had been prepared under the direction of one of the original commissioners, Professor Paul Robinson. It was mathematical and complex, with harm values, multipliers, and sanction units. It sought to account for a wide array of aggravating and mitigating factors. It attempted to achieve something approaching perfect justice. The reaction to that draft was resoundingly negative. Circuit Judge John Newman, an early proponent of the need for sentencing guidelines, wrote, "My first point challenges a basic assumption that underlies the entire proposal, the idea that in every increment of harm that can possibly be measured should be reflected in an increment of additional punishment. I seriously doubt there is moral validity to this idea. Judge Newman predicted the complexity of the proposed system will create enormous grounds for error in application of the guidelines and appeals to challenge the sentence. This is the inevitable consequence of a system that tries for ultimate precision. If everything matters, then every statement of definition must be interpreted with inevitable mistake and subsequent legal challenge. Although later discussion drafts were less complex, the final product, which became effective in 1987, was obviously influenced by the original draft. The 1987 Guidelines Manual was complex and mathematical and sought to account for myriad aggravating and mitigating factors other than the offense of conviction. Most stakeholders reacted negatively to the new guidelines. Over 200 federal judges ruled that the new guidelines were unconstitutional. But in 1989, in Mastretta versus United States, the Supreme Court, over Justice Antonin Scalia's lone dissent, upheld the constitutionality of the Commission and its new guidelines. 16 years later, in United States versus Booker, the Supreme Court, with Justice Scalia now in the majority, invalidated the mandatory guidelines as violating the right to a jury trial under the Sixth Amendment. As a temporary fix, a different majority of that court, in a remedial opinion written by Justice Stephen Pryor, one of the original commissioners, held that the guidelines could continue to operate as advisory. But the remedial opinion told Congress that, quote, the ball lies in its court to come up with a workable and constitutional guideline system. Congress has not picked up the ball. Over 11 years later, the advisory guideline system created by the court as a short-term remedy in Booker remains in place. Well over 500,000 federal offenders have been sentenced under the post-Booker guidelines. The manual has grown in complexity, and empirical evidence proves that sentencing disparities, the primary concern that led to the creation of the guidelines, have increased since the guidelines became advisory. I want to propose a solution both to the original problems created by the mandatory guidelines and to the new problems created by Booker. My proposal adheres to the first principles of sentencing reform initially articulated by Judge Marvin Frankel in the early 1970s and later embodied in the Sentencing Reform Act of 1984. But my proposal differs from both the original guidelines and the post-Booker guidelines. I propose that Congress and the Commission create a system of presumptive guidelines, a radically simpler system with wider sentencing ranges and fewer enhancements. Those enhancements would be found by juries, not judges, unless a defendant admitted to the enhancement in pleading guilty. This system would better resemble the architecture proposed by the American Law Institute in our revision of the Model Penal Code. 3 different experiences influence my perspective. First, since 2004, as a federal judge, I have decided more than 1,000 sentencing appeals. Second, from 1997 to 2004, as Attorney General of Alabama, I worked closely with other state leaders to create the Alabama Sentencing Commission, which promulgated simpler guidelines. And third, since 2013, I have served as a member of the U.S. Sentencing Commission. Since that time, the Commission has made significant strides toward reforming federal sentencing. For instance, in 2014, we unanimously reduced the guideline penalties for the majority of drug trafficking offenders, including those already serving their prison sentences, by approximately 25%. Earlier this year, we promulgated a reform of the career offender guideline and other provisions for recidivists by simplifying the definition of a prior crime of violence. And last month, we promulgated an overhaul of the immigration guideline for illegal reentry cases. These reforms affect the great majority of federal offenders and represent what I think is most of what we can hope to achieve working with the current manual. Instead of continuing to tinker with the advisory guidelines, we now need to tackle a more fundamental reform. We need to address why the guidelines have failed to achieve the first principles of sentencing, and consider how, with structural reforms, they could do so in the future. I will begin by discussing those first principles. I then will discuss how the original guidelines went wrong, how Booker failed to fix those problems and made some things worse, and why we need a second generation of guidelines to implement the first principles of sentencing and avoid the elusive quest for perfect justice. My comments do not reflect the official position of the Sentencing Commission. They are solely my opinions, at least for now. The first principles of modern sentencing were initially articulated by Judge Frankel over 40 years ago. Those principles, embraced by Senators Kennedy and Thurman in the passage of the Act, are: 1, sentences should meaningfully reflect the purposes of punishment. 2, a sentencing system should result in proportional punishments. 3, a system should avoid unwarranted disparities. 4, a sentencing system should achieve reasonable certainty in sentencing. 5, there should be honesty in sentencing. And 6, there must be transparency in the sentencing system. Judge Frankel envisioned a codified system of weights and measures with binding rules, his description of what later would be called sentencing guidelines. He proposed an expert commission on sentencing to create the guidelines. And he stressed that appellate review was necessary to enforce the guidelines uniformly throughout the country. Judge Frankel also believed, both before and after the Sentencing Reform Act, that federal sentences were often more severe than needed to achieve the purposes of punishment. Judge Frankel was under no illusion that his proposal would lead to perfect justice. As he explained, he was not operating under, quote, delusions of precision about the level of detail needed in the guidelines. Although his ideas were still nascent in 1973, he proposed simple guidelines that, quote, could be graded along a scale from perhaps 1 to 5. Fast forward. In 1992, when Judge Frankel gave the keynote address at the Yale Law Journal Conference on the federal guidelines, the new guidelines had been implemented for only 3 years following Mastretta. Judge Frankel recounted the criticisms that the guidelines were complex, rigid, harsh, too mechanical, and unduly constrained judicial discretion concerning mitigating factors. He intimated his agreement with those criticisms, which his friend Judge Newman later confirmed after he died. Judge Frankel was mostly right in 1992, and his criticisms became more cogent in the ensuing decade. So let's begin with complexity. The 1987 manual was 268 pages without appendices. By 1992, when Judge Frankel gave his speech at Yale, the manual was 393 pages. By 2005, when the court decided Booker, the manual had grown to 514 pages. It's currently 542 pages, twice as long as in 1987. Many of the most commonly applied guidelines, such as those for fraud and theft and for drug trafficking, have expanded in a disproportionate manner. For instance, in 1987, the original drug trafficking guideline was 115 words long without the quantity table and commentary. That same guideline today has 1,397 words. The expanding girth of the manual has been a function of nearly 800 amendments since 1987. Many of those amendments were the result of directives from Congress, which required or strongly suggested that the Commission amend the guidelines, typically by increasing penalties. Often those amendments concerned minor or arcane sentencing issues, such as the weighty issue of the enhancement for a theft or destruction of property from a national cemetery or veterans memorial. The original guidelines were rigid. They required the sentencing judge to be as much of an accountant as an arbiter of justice. They required and still require numerous mathematical calculations, a base offense level plus or minus myriad specific offense characteristics plus or minus several adjustments, followed by a criminal history calculus. That calculation then yields a narrow sentencing range, for instance, 46 to 57 months or 70 to 87 months of imprisonment. Before Booker, The guidelines constrain judicial discretion to sentence outside those narrow ranges. So long as the Commission had considered a particular issue about offense conduct in the guidelines, a departure from the guidelines was warranted only if the factor was present to a degree substantially in excess of that which is ordinarily involved in the offense of conviction. The manual also restricted the consideration of offender characteristics, such as an offender's age, mental illness, drug addiction, or family responsibilities, as a basis to depart from the sentencing range. Much of the rigidity was dictated by the Sentencing Reform Act. Congress directed the Commission to narrow sentencing discretion in three ways. One, to create a detailed set of sentencing guidelines that, quote, reflect every important factor relevant to sentencing. Two, prohibit or limit consideration of several personal characteristics of defendants. And three, limit the breadth of the individual sentencing ranges within the guideline sentencing table such that the maximum of the range shall not exceed the minimum of the range by more than the greater of 25% or 6 months, which is known as the 25% rule. For the most part, the Congress, not the Commission, made the guidelines rigid, although the Commission exacerbated the problem by making the guidelines complex and mathematical. The guidelines were and are severe. In 1992, when Judge Frankel gave his speech at Yale, the average federal prison sentence was 66.7 months. Before the guidelines, the average federal prison sentence was 65.2 months, yet the amount of prison time actually served was much lower because of the availability of parole, which was abolished with the advent of the guidelines. Today, the average federal prison sentence is 53 months, over a year lower than the average in 1992, but still longer than the average time served by federal prisoners before the guidelines. And it is over 1 year longer than the average sentence for a felony conviction in state court, where the offense, such as murder or rape, may be far more serious than most federal felonies and where parole may shorten the sentence actually served. A lot of credit or blame goes to Congress. In the Sentencing Reform Act, Congress not only abolished parole, but also envisioned more severe sentences, particularly for white-collar offenders and drug traffickers. And the original commission faithfully followed Congress's directives. Congress's enactment of mandatory minimum penalties for drug trafficking, firearm, and child pornography offenses since the mid-1980s has also contributed to the increase in the federal prison population. And during the last 3 decades, Congress has issued many directives requiring or strongly suggesting that the Commission increase guideline ranges for a variety of offenses. In addition to their complexity and severity, the original guidelines suffered from another problem, one that led the Supreme Court to invalidate the mandatory guidelines in Booker. Because the Act required judges, not juries, to find sentencing enhancements by a preponderance of the evidence, it was unconstitutional. In its remedy, the Supreme Court excised the provisions that made the guidelines mandatory and made them advisory. That remedy meant that juries would not be required to find sentencing facts. District judges still find those facts by a preponderance of the evidence, but judges now enjoy the discretion to vary from the advisory guideline ranges. The Booker remedy, now in its 11th year, has not advanced Judge Frankel's first principles. On the contrary, the advisory system has made at least some things even worse. Judges are now freer to consider offender characteristics. That freedom has led to growing disparities. Data analyses by the Commission established that the disparities are not only a matter of judicial assignment or the district or circuit in which sentencing occurs. Differences in sentencing length are also associated with race and gender. Black males receive higher sentences than white males, and women receive lower sentences than men, even after controlling for other factors. I do not suggest that federal judges are biased, but when a sentencing system gives judges free rein to consider virtually all aspects of an offender's history and characteristics, those associated with offenders' demographics such as employment, education, and family support inevitably will result in sentencing disparities correlated with race, class, and gender. That fact explains why the original Commission restricted departures from the guideline range based on individual characteristics. Perhaps the original Commission went too far. But Booker effectively removed all limitations. We went from one extreme to the other. The advisory guidelines are in some ways the worst of both worlds. On the one hand, they have increased sentencing disparities. On the other hand, they are as complex as the mandatory guidelines. Indeed, they are even more complex today than they were in 2005, although a court has to jump through all of the same hoops that existed before Booker and then engage in an additional inquiry about whether to vary from the guideline range. The Commission has continued to amend the guidelines on a regular basis, and Congress has continued to seek to influence the Commission. In addition to legislation directing the Commission to make the manual more complicated, members of Congress frequently urge the Commission to amend the guidelines when those members have been unable to enact legislation to raise statutory penalties. For instance, last year, 2 senators, one from each party, that was bipartisan, requested that the Commission amend the guidelines to increase the penalties for, quote, candy-flavored drugs, even though we were unable to find any evidence that candy-flavored drugs had become a national problem, requiring yet another sentencing enhancement. One might expect that a sentencing regime with advisory guidelines would engender fewer, not more, attempts to add minutia to the manual. From my experience on the Commission, I've not seen any evidence of a reduction in attempts to add minutia. Despite his misgivings about the original guidelines, Judge Frankel remained a proponent of some type of mandatory guidelines to achieve the principles of sentencing that he articulated in the early 1970s. He believed that the guidelines needed to be retooled. Like other critics, Judge Frankel recognized that the Commission had followed congressional directives in promulgating the original guidelines. Thus, the retooling that he proposed had to involve Congress. I agree with Judge Frankel's perspective. We need a system of enforceable guidelines in which judges adhere to sentencing ranges absent substantial and compelling reasons to depart from them. And we need to cabin the unrestrained consideration of offender characteristics. Otherwise, we will continue to see unwarranted sentencing disparities and a lack of certainty in sentencing. But we also need some consideration of offender characteristics, and we need to reduce the severity of some guidelines, at least for nonviolent offenders. I prefer the term presumptive instead of mandatory because even the pre-Booker guidelines were never truly mandatory in the same sense as a statutory mandatory minimum. Presumptive guidelines would bind judges in most cases subject to meaningful appellate review, but they would have some flexibility. They would also be less objectionable to judges than the pre-Booker guidelines if they had wider ranges and less severity. I do not propose making the current guidelines presumptive. I propose a radically simpler system that would incorporate only the most important and common aggravating and mitigating factors. For instance, the drug trafficking guideline would look more like it did in 1987. Many of those factors in the current guideline, called specific offense characteristics in Chapter 2 and adjustments in Chapter 3, would be deleted. Perhaps it would have aggravating factors for possession of a firearm or 1 or 2 other common aggravating factors, but it would not have the laundry list of aggravating factors in the current guideline. Many factors could be moved to the commentary as reasons for sentencing courts to consider in deciding where within the broader ranges to impose a specific sentence. A presumptive guideline system would have broader ranges. Congress would need to amend the Sentencing Reform Act by repealing the 25% rule. That rule in large part explains why the current sentencing table is so complex, with 258 different cells and ranges that are so narrow. If the 25% rule were repealed, the Commission could create broader ranges and a simpler sentencing grid. To comply with the right to a jury trial under the Sixth Amendment, a presumptive system would use juries to find aggravating facts that would raise a guideline range. The preponderance standard used by judges in the advisory system would be replaced by the reasonable doubt standard, and related constitutional rules would apply too, such as the requirement that sentencing facts that would raise the guideline range be pleaded in an indictment, and the requirement that the defendant be able to confront witnesses against him about facts that would raise the guideline range. In other words, sentencing under a presumptive system in many ways would resemble a criminal trial. The days of uncharged, relevant conduct found by a sentencing judge by preponderance of the evidence, often based on hearsay in a pre-sentence report, would be over. Based on the experience of several states that have enacted presumptive guidelines in the last decade, it is unlikely that a presumptive federal system would lead to a significant number of lengthy contested sentencing trials. The vast majority of defendants likely would continue to plead guilty both to the charge and the relevant sentencing facts that would raise guideline ranges. But if we ended up having more sentencing juries, that development would not be a bad thing. The jury is the primary feature of the American criminal justice system that promotes democratic accountability under the Constitution. A word about severity. I do not suggest dramatic, across-the-board reductions in federal sentences. Many offenders, particularly violent offenders, sex offenders, and large-scale drug traffickers and fraudsters, should go to prison for a long time. But penalties could be reduced for many first-time and low-level nonviolent offenders. Criminologists tell us that certainty and swiftness in punishment are more important than severity in punishment. In a system with less severe penalties and broader ranges, most cases would not present a reason for departure from the guideline range. Downward departures would be appropriate in those cases outside the heartland where the guidelines fail to account for some compelling offender or offense characteristic. Because of the constitutional requirement that aggravating facts that would raise ranges be pleaded in an indictment and proved to a jury beyond a reasonable doubt, upward departures would no longer exist in a presumptive range. For criminal history calculations in the system, the current Chapter 4 of the manual should be retained with minor simplifications. The criminal history rules, though complex, work well and have received relatively little criticism. There is strong empirical basis for retaining those rules. There must be a meaningful appellate review in a presumptive system. Let me explain what I mean by contrasting what I envision with what existed before Booker and what exists now. Before Booker, appellate courts had to deal with the same guidelines minutiae that district courts did. After Booker, appellate courts continued to check the district court's math about guidelines minutiae, which what is called review for procedural reasonableness. In addition to that review, appellate courts also review whether sentences are substantively reasonable. I and other appellate judges liken this form of review to deciding whether a sentence shocks the conscience. This highly deferential review rarely leads to reversals. Reasonableness review does almost nothing to promote the first principles of sentencing. If an appellate court reverses a district court for miscalculating the guideline range and remands, the district court can apply the correct guideline range and vary from that range to impose the exact same sentence as before. Under the shocks of the conscience standard, appellate review almost never leads to a reversal of a sentence as substantively unreasonable. For presumptive guidelines, meaningful appellate review would do two things. First, appellate courts would review for clear error whether sufficient evidence supports an enhancement. And second, they would decide whether a district court erred in departing below a guideline range. They would review de novo questions of lawful authority to depart and review for abuse of discretion exercises of that authority. Departures would be governed by the statutory purposes of sentencing and would be accompanied by written reasons. Appellate review would deter excessive departures and reduce the types of sentencing disparity that we see in the current advisory system. This proposal for guideline reform is not mine alone. Similar proposals have been made by others, including former Commission Chair Judge William Sessions and the Nonpartisan Constitution Project. But my proposal differs in one important respect. I propose that Congress enact into law the portions of the new guidelines that would increase guideline ranges instead of allowing them to go into effect 180 days after the Commission promulgates them, as ordinarily happens under current law. Any later amendment to the guidelines that increases penalty ranges also should be enacted into law by Congress. Requiring Congress to enact the enhancement for presumptive guidelines would serve two purposes. First, it would remove any constitutional doubt about the guidelines in a post-Booker world. An argument could be made that without legislation, the new guidelines would be the product of an unconstitutional delegation to the Commission. A second reason for requiring Congress to enact aggravating factors into law is that it would likely deter increases in severity and complexity. Of course, Congress could change minutia in the guidelines, especially by adding aggravating factors, but the cumbersome bicameral legislative process would make change more difficult than when the authority is delegated to a 7-member commission. And Congress would have to account for the fact that prosecutors would have to prove any new aggravators to a jury beyond a reasonable doubt. The Commission could still amend the presumptive guidelines without action by Congress in 3 ways. First, the Commission could amend the commentary recommending higher or lower sentences within the wider ranges. Second, the Commission could amend the provisions for departures. And third, the Commission could amend the provisions about an offender's prior convictions. The Commission also could continue to recommend statutory changes to Congress and to collect and analyze its data. That data analysis has been instrumental in amending the guidelines for the better in recent years. Before I conclude, let me say a brief word about mandatory penalties enacted by Congress. Since the beginning of the guideline era, the Commission and many others, including Justices Pryor and Kennedy, have noted the disconnection between the blunt instrument of mandatory minimums and a finely tuned guideline system. Congress enacts mandatory minimums because it wants to make sure federal judges don't impose unduly lenient sentences for certain types of aggravated offenses or for offenders with serious criminal records. The presumptive system that I propose, which Congress would in part enact into law and in which downward departures would require substantial and compelling reasons, arguably would render mandatory minimums unnecessary except for perhaps egregious offenses. There is no such thing as perfect justice in sentencing. The Sentencing Reform Act of 1984 and the original guidelines both were good faith efforts to achieve something close to perfect justice. As the past 3 decades have proved, Congress and the Commission were wrong to pursue that elusive goal. They should have adhered more to Judge Frankel's vision. The perfect should not be the enemy of the good. The Commission should work with Congress for a bipartisan reform of federal sentencing that leads to a simpler presumptive guideline system. Thank you.
I think that the ALI rejects the idea that the perfect is the enemy of the good, but that was a wonderful and important address. The judge says that he will listen to questions. Why don't we take 2 and then get back to our other work?
So I have a question about a historic question. My name's Jim Robertson. I'm from San Francisco. So historically, when the mandatory guidelines were in effect, the question is about judicial discretion. How much judicial discretion was there exercised that might have been called failure to obey the guidelines? So we have a similar situation in California. We had 3 strikes, you're out. What happened was many of the state court judges simply didn't enforce the mandatory sentence provisions, and that ultimately changed. So my question is directed to the mandatory period and judicial discretion.
Federal judges followed the guidelines. I mean, I think that's the history. They followed the guidelines. There was, essentially de novo appellate review in many respects, and the guidelines were enforced and followed. There was I meant to call on you. Yes.
Thank you very much for extraordinarily thoughtful address. And Martin Frankel is a friend of my family. He meant well. I don't think he quite realized what he was telling us.
Well, the good news is that at the state level, where most sentencing occurs, I think Kevin Wrights would tell you he achieved a lot.
but here's my question, which is a very urgent matter now. It doesn't quite fall within your bailiwick. Maybe it does, because judges can do a lot by saying things in dicta. There is a absolute stasis, a paralytic condition on the exercise of pardon power. And what happens in DOJ now, and I know the people who used to work there, is that they just do not process it. And the White House, I was quite surprised that the president didn't think to do this, has not pushed them to try to actually to examine and form an opinion upon the pending pardon files. So do you think, as I guess I do, that the judiciary may have some role in pressing the executive branch to exercise what is the deep complement to the initial act?
Well, one thing I have done as a circuit judge is, particularly in the collateral review of criminal convictions, is when we've had big fights about it on our court, and I have said no collateral review is available in this circumstances. I have nevertheless pointed out that there is a place where that mercy can occur, and in fact, pretty big fight that we had on our own court, the president ended up pardoning this individual, which, that the clemency power is there for a reason. We've met the commission. I think part of what maybe contributed to the problem is the commission has this power to retroactively amend the guidelines and provide sometimes for the mercy that you're talking about, and it lets perhaps the executive to a degree off the hook. We've met as the commission recently with the pardon attorney for the White House, and as you know, there have been a substantial number, an increasing number, very recently, I grant you, of commutations by the president. No, but that piece is picking up, and I'm going to be surprised if by the end of the year there aren't a fairly significant number by this president.
Last thought, you all might want to look at how DOJ has staffed or failed to staff the work of the department.
I can promise you this: not a meeting of the commission goes by when we don't talk about this and don't have some report from DOJ or from the executive branch in some manner.
Thank you. I think that's all we have
Thank
time
you.
for. I can't thank you.